And while that is true, because that still remains true, the NDPP did not report to the minister through me. But the second aspect that I did not clarify as well as I ought to have is the fact that the documents that are submitted to the minister in the form of memoranda are routed through my office, well, my then office, the deputy minister, and then the minister, and way back. So this is what this affidavit seeks to clarify, because that aspect I totally missed in my original affidavit, or at least I did not explain it as well as I would have been expected to explain it at that time. So that is the essence.
Thank you. I think just to get straight to it, I'm going to ask you to read the affidavit into the record without me interrupting, from paragraph 4 until paragraph 6.
Thank you very much for the opportunity. Paragraph 4. The fundamental changes I wish to and hereby make to my original affidavit relate to the routing of the documents originated by the National Prosecution Authority, the NPA, and destined for the Minister of Justice and Constitutional Development is the following. 4.1. The documents submitted by the NPA to the Minister of Justice and Constitutional Development are routed through the Office of the DG of Justice and Constitutional Development, are routed through the Office of the DG of Justice and Constitutional Development. Sorry, I repeated that. It is for this reason that I would have noted and in some instances supported the content therein. In this context, therefore, my previous affidavit stated that the TRC submissions were not routed through my office, when in fact they were indeed routed through my office or the Office of the Director General. This statement was made by me and is incorrect. The reason of the statement, which I genuinely believe to be correct at the time, was due to the lapse of time affecting my memory and the true state of affairs, and was not intended to deflect or mislead the Commission or the interested parties on the true position of the routing of documents in the Department of Justice and Constitutional Development. It wasn't until I saw the affidavit of Asmita Tako, I don't know whether I'm spelling the name correctly or I'm pronouncing the name correctly, so my apology, of Weber Wenzel, and the annexures thereto, that I saw my own signature, which triggered the document routing process within the department, which I hereby explain and clarify. 4.2, the above correction applies to the following paragraphs of my aforesaid affidavit, namely paragraph 8.4, 8.8, and 8.10. Other substantive paragraphs, namely 8.5, 8.6, 8.7, 8.9, 8.12, and 8.13 are not affected by this error, at least not in any significant way. This was an honest error on my part, which is sincerely regretted, and I did not intend to cause any harm to the work of the Commission or that of the interested parties to the Commission's work. Do I need to continue?
Yes.
Oh, thank you. Other than the changes referred to in 4.2 above, which are supported by my signature and confirm, therefore, the routing process of the NPA memoranda to the Minister of Justice and Constitutional Development, there are no further changes I wish to make. I still confirm that I have not sat in any meeting of the Minister of Justice and Constitutional Development where discussions were held on the prosecution or otherwise of the TRC cases. To this end, I have communicated with Advocate Mthunzi Maka of the NPA, requesting him to provide me with evidence of meetings I have attended where the NDPP or the DPPs of the NPA discussed specifically the TRC cases with the Minister of Justice and Constitutional Development where I was present. Advocate Maga responded to me via text, a message dated 19 August from, I don't know how to pronounce the name again, Shabnam Singh, Senior State Advocate, TRC component, NPS, as follows. Dear SD, during the period I have overseen the TRC matters, the name of Ms. Nongululeko Sendane has never come up. Kind regards.
Thank you very much. I think that's all that I would have wanted you to put on record. Chair and Commissioners, that's all from the supplementary affidavit. I would leave it at that and allow my colleague, Advocate Vani, to proceed with the cross-examination.
Yes. Thank you. Mr. Vani?
It's muted. You're muted.
You are muted. You are not audible.
Thanks, thanks, Commissioner. In fact, when I was not audible, I was asking whether I was audible. It has been a long week. My apologies. Am I audible now?
Yes, you are audible and visible.
Thank you, Chair. Ms. Santani, thank you very much for coming back to the Commission. I'm sorry to hear that your health has not been good recently. I hope that you're on the mend. And also thank you for your supplementary affidavit with those corrections to paragraphs 8.4, 8.8 and 8.10. We accept that was an honest error. And indeed, I think I should place on record, and we've put it into our application, that we believe the documents in question that you refer to, and which we refer to at 6.5 and 6.6 of our application, that these should have been provided to you previously, and they should have been put to you during your evidence in chief. And if they had, there might have been no need for you to return today. And in fact, because they weren't, this is really why we had to apply to cross-examine you. Having said that, let's deal with a few matters. Can I check? You do have a copy of the application, that's the affidavit of Ismita Thakur, before you?
Yes, I do, and I did. Thank you.
Great. So we're just going to loosely follow that, and then I'm going to take you through aspects of your statement, and then we'll turn to some of those documents, and I'll ask questions. Before we do so, would I be right in saying that, or let me just confirm your period at the NPA. Let's just remind ourselves, and that's at page 9, paginated page 9. I think it's the second or first page of your statement. So we turn to paginated page 9 and at paragraph 8. Let's just confirm that you were the Director General of the Department of Justice between 4 January 2010 and 30 March 2016.
Yes, I confirm.
Thank you. So, and now I'm referring back to the Ismita Thakur affidavit, looking at paragraph 8.2 on page 5. You can see it makes reference to an NPA annual report of 2009 and 2010. So I want to put that to you. You'll note we don't have to go to it, but Commissioners, it's at page 67 of the bundle, and there's just one quote you want to put to you. The annual report says that before prosecutorial decisions could be made, cases had to be investigated, but that since 2003, the NPA had struggled to secure the necessary cooperation in this regard. Given that the NPA was reporting on that struggle to get investigations done, would I be right in saying that the issues around the TRC cases came onto your radar quite early?
I'm not sure whether I understand the question. The issues of the TRC came to my attention quite early. Is that the question?
Well, yes, that's the question, because this was a public report of the NPA. So presumably you and your staff would have had sight of it.
Yes, I would have.
Yes. And then, in addition to that, the Constitutional Court, and this will be referred to paragraph 8.1 of that same document, the Constitutional Court in February of 2010 issued a judgment on the special dispensation of political pardons, essentially setting it aside because victims had been excluded from the process. We've given the citation and the footnote, and there's a media summary of the judgment at page 64. So essentially what we're saying is that together with that annual report, that suggests that you in the department had some knowledge of issues arising around the TRC cases during the course of 2010.
Yes, there would have been knowledge of the TRC cases prior to, well, during that period that you've identified. I'm trying to understand the question.
Yes, no, that was the question, and you've answered it.
Oh, thank you.
Let's turn back to your statement. And we were on page 9. I'll just wait for you to get there. That's paginated number 9, red number 9. So you should have the cross-examination bundle with you, and you'll notice on the top right-hand corner of each page there's a big red number. Just to make our lives easier, we're just going to refer to those numbers rather than the individual page numbers of the separate documents. Can I assume that you are at page 9?
Yes, I am on the red page 9.
Thank you. So at the bottom of that page at 8.3, you set out your responsibilities. We're not going to go through them in detail, but they included operational, strategic policy development, accountability for the overall budget. And here we do make note of the certain paragraphs that your supplementary affidavit has corrected. And we see that 8.4 is one of those paragraphs. It says the NPA reported directly to the minister, not through the DG, that you have corrected. But I do note that you haven't made any adjustments or corrections to 8.5, 8.6, and 8.7. We certainly agree with you that the NPA was an independent entity. It did not fall under the authority of the DG. Am I right in saying that if you're suggesting that the NPA fell well outside of your purview, that would be incorrect?
The prosecutorial responsibilities fell outside my purview. And
yes, there's
if that
no
answers your
dispute
question,
on that.
yeah. That,
Yes,
that
thank you.
does
There's
not change.
yes, yes. No, in relation to prosecution decisions, we totally accept and agree that that's not your responsibility. You have no authority to deal with those issues. But where there are, perhaps I can call them systemic issues that arise within the NPA, that would fall within your purview and that of the minister.
Systemic issues, I am not sure. This is what I would like how I would like to respond to that question. The substantive matters of prosecution and anything related to that is the function of the NDPP. The support functions associated with the work of the criminal justice system, not just the NPA, the criminal justice system, is vested in the office of the DG just to provide the support that is required. If I'm understanding your question correctly, that's the response I would like to give.
Yes, thanks. Thanks for that clarification. So I am correct in saying that from time to time, and as we can see from the documentation, various issues would be brought to the attention of yourself, the Deputy Minister, and the Minister for your consideration and input. So it wouldn't be correct to say that you would not have any knowledge of matters that needed to be resolved within the NPA.
The answer to your question is twofold. To the extent that the issues would have been elevated, I would say those issues, and I'm trying to think of an example of those issues. But if I were to use the examples, commissioners, in terms of matters that could have come to, and TRC or not, but matters that could have come to the attention of the minister would have been, we don't have enough courts, we don't have tools of trade, and the related issues associated with that. Those are administrative issues which the DG can deal with, but not the substantive matters of the cases are taking too long in courts and those types of issues. Those are not necessarily the issues that the DG deals with. Those are fall within the purview of the minister and the NDPP.
They are operational matters.
Yes, thank you.
Right. We will turn to some of those issues shortly. But I just want to put a quote to you from the current Minister of Justice, Ms. Kabayi. And I just want to ask whether you agree with it or not. And she's talking about the role of the Director General. Commissioners, it's a short quote. It comes from the transcript of her evidence on day 72. It's at page 36 of the transcript. It reads as follows. In my experience as Minister, and if I may, when a submission is made, the submission comes from the author of the submission, who then transmits it through. Now, the Director General needs to sign the memo because in terms of the process, Director General is the advisor of the Minister in how you would see things. So the Director General has a responsibility to look at the memos that come to the Minister, to be able to advise the Minister, one, in terms of compliance of issues and law, but also if what is being recommended, the Minister can consider. Would you agree with the Minister in relation to the role of the DG as an advisor to the Minister?
There is I won't agree wholeheartedly, or at least completely, with that statement. To the extent that the DG will advise the minister from time to time, yes, I will agree to that. But it depends on what the minister is being advised on, which I think is the departure point between the statement of the current minister and my understanding. My understanding is that the minister is advised that this is the memorandum, this is what the NPA is saying. In fact, it's not even summarized. The memorandum goes to the minister direct from the NPA straight to the Minister of Justice. The DG would read the memorandum and see whether some of the issues the DG is agreeable to and then route the memo. In the discussion that would happen, and sometimes doesn't happen, because the minister has a political advisor who advises on hardcore political issues, and the TRC would have been one of those. And I'm not saying there were no discussions between me and the minister on those, but primarily the minister always has a political advisor that will advise. The DG will advise on administrative issues arising from that. If, as I've indicated, lack of courts, court space, lack of administration, those types of things, yes, the DG will advise on that. It doesn't mean, though, that if the minister is requesting specifically for the advice, a particular advice, he will not get it from the DG. And that's why I'm saying I will agree partially, not fully. Thank you.
Thank you for your perspective on that. Then let's turn to one of the documents in question, and that's that red paginated number 16 of the bundle. I'll just wait for you to get there.
I'm there. Thank you.
Thank you. So this is a ministerial memorandum from the Office of the NDPP, from Advocate Njiba. She was the acting NDPP at the time. It's addressed to Minister Radebe. It's a memo to the Minister in terms of Section 33(2)A of the NPA Act. It's titled Report of Investigations and Prosecutions Emanating from the TRC. It's dated 30 May 2013. If we can just quickly jump to page 30, you will note that you have signed that memo. It looks like it was on the 4th of July 2013. And next to the word noted, you appended a tick. Is that correct?
Yes, it is correct.
Thank you. So it's quite a long memo. We don't have time to go through it in any huge depth, but I will raise a few passages with you. The purpose of the memo is set out in paragraph 1. And perhaps I'll just read that so we're on the same page. The purpose of this memorandum is to provide the Honourable Minister with a comprehensive report on the investigations and prosecutions of matters emanating from the TRC as undertaken at the meeting of 5 April 2013. And let's perhaps just jump to a detailed history an account of what had happened previously, but we can jump to page 22. So on this page and a few others, there do appear to be various systemic issues or underlying matters that is raised with the Minister, and we would say with you as well, in relation to these cases and why the cases had not been expeditiously handled. So, for example, at paragraph 5.16, it's noted that I'll read it. As a result, 350 of the 400 cases were finalized. In respect to the remaining 50, further investigations were necessary before decisions whether or not to prosecute could be taken. 517, both the DSO and SABC were requested to investigate the remaining 50 cases, but declined to do so. 518, the ANDPP at the time, Dr. Ramaita, put the management of TRC cases on hold pending the formulation of special guidelines. So would you agree that passages like that would have alerted you to underlying issues, and perhaps alarm bells were now ringing?
Yes, I mean, it's very express in the memo. So the challenges that were being experienced by the NPA were well articulated and understood.
And if we drop to 521 at the bottom of the page, it talks about the guidelines and the criteria. We're not going to go through. It's a long paragraph that it was set aside in the High Court as unconstitutional. The second half of that paragraph says, as a result of a decision whether or not to appeal the judgment, the investigations could not commence. Did it occur to you at the time that was improper, that murder investigations should not be dependent on civil litigation being resolved?
No, it didn't occur to me in the way that you are putting it. This memorandum was listing a plethora of challenges, some of which were within the competence of the NPA to resolve, some of which were in the institutional arrangements between the ministry and the NPA and whatever other work that needed to be done, as far as I understand. Therefore, I can't say in this commission that this would have raised eyebrows necessarily, simply because these issues had been known. And maybe if I can step back as now a South African, not a DG of Justice, the matters that had arisen from the NPA, and some of them are articulated in the memorandum that you are referring to and in the other memos that are also part of this pack, is that there were many things that happened. There were dispensations that were given, and the impact of those dispensations that were given earlier resulted in some of the delays and the challenges that were then experienced by the NDPP and the NPA at the time of this memorandum. If you read the whole memorandum, you will see that some of these challenges did not emanate from what was the date of this memorandum? From 2013. Some of them came way back in early 2000s. And they are articulated in this memorandum and in the other memoranda that are in this pack. So what I'm trying to get to, coming back to your question, is that the knowledge that there were problems, I cannot say was not there. The fact that we are still talking about it today, it means that there were indeed fundamental problems. And each of those problems needed time, based on this memorandum, needed time to be resolved. It wasn't something that was going to be resolved in maybe a month or two. It needed regulations in some instances and those types of things, which take an inordinate amount of time to finalize and then get back on track. There were other issues like the World Cup. I can't remember whether it's in this memo or it's in a different memoranda, where those issues, when a prosecutor says we are prioritizing the World Cup cases right now, there's nothing that I would, even as I sit here as a witness, say it didn't make sense, because that was a short-term intervention that was required, as an example, for the World Cup, beyond which the prosecution of cases could continue. Thank you.
Thank you for that explanation. And since you've raised the World Cup, perhaps let's just turn to the next page, 23. And you're right, the World Cup is in fact raised in 528, although perhaps before we get there, let me just summarize other issues arising as to why investigations wouldn't go ahead. And I do make the point that and I accept the point that you've made, that these things happened in previous years before you became a Director General. So, for example, 525, SAPS notified the then acting NDPP advocate Mshe that TRC cases couldn't be pursued pending the outcome of the Ginwala Commission. And 527, once the Ginwala Commission had concluded its work, that was at the end of 2008, the PCLU then commenced negotiating with the SAPS to investigate the remaining cases. And then lastly, as you highlighted, eventually the DPCI agreed towards the end of 2009 to take on the TRC cases, but only after the end of the World Cup, which concluded in July of 2010. So again, I imagine that there were alarm bells, because, why should murder cases stop? Because a commission of inquiry was looking at the suitability of a particular NDPP. And again, why should the NPA have to negotiate with SAPS for murder cases to be investigated? Surely this happens in the normal course.
I'm not able to answer that question because I'm not coming from the NPA, so I wouldn't know why they took those decisions. I wouldn't know that. What I can say is that if you look at this whole thing in totality, there were many interventions and breaks in the decision making around the prosecution of those cases. And that decision making would or could have been discussed at a political level, I don't know. Could have been discussed between the NDPP and the minister, I don't know. But I don't know, because I was never in any of these discussions where we were discussing and saying this can happen because of this reason. The memorandum does also not reflect that decisions could not be made because of discussions that were held with me. Thank you.
Thanks. But just from the perspective of a...
Sorry, Mr. Vani, but say particularly the Ginwala matter, it doesn't make sense to me that prosecutions have to be stalled or stopped because of the Ginwala matter. It's okay, it involved the National Director of Public Prosecutions, but and it's not a particular case that relate to what the NDPP would have done that would impact the prosecution of those cases. Why should all other cases stop? Does it make sense to you? It makes no sense to me. Maybe you can help.
Unfortunately, I'm unable to help the Commission in terms of whether it makes sense or it doesn't. It's not something that I can opine on after the decision had been made to delay the prosecutions. But I could also ask a question, a different question, in saying if the NDPP has made a decision not to proceed with the prosecution of the TRC cases, does the DG have the power to go to the NDPP and say, you can make that decision to not prosecute? So it's again, it's many of the interpretations that we can put on powers and responsibilities of parties at the time. What I would like to conclude on this point and say is that in the final analysis, it is the NDPP that has the power and authority to decide whether to prosecute or not prosecute and when to prosecute. It's not the decision of anybody else. We may wish that the NDPP prosecuted earlier, completely, but that can only be a wish. The reality is that the NDPP, faced with whatever issues he would have been faced with, he would have come to that determination.
Yes,
Thank you.
but yes, look, I hear what you say, but I'm not imputing any dereliction to the DG, even as a civilian, and even if I'm not asking as a commissioner, that does not make sense.
Again,
Not that you should have done something as a DG.
Again, I don't understand the rationale how the NDPP would have arrived to that conclusion. And I think I'm not the correct person to speak to someone's mind, unfortunately.
Okay, thank you.
Thank you.
Thank you, Mr. Vani.
Thank you, Commissioner. Ms. Santoni, just a small correction. This was not the NDPP suspending prosecutions pending the outcome of the Ginwala Commission. If we just revisit paragraph 5.25, it was SABC that notified the NPA that investigations could not proceed pending the outcome of the Ginwala Commission. So we're actually talking about the police here, not the NPA. Having said that, to be fair to you, this was before you assumed office as DG. And I also agree with you that you had no power to issue instructions in any event. The only point we wish to make is that on reading this, as a senior official in justice, it must have raised eyebrows, if not alarm bells.
Well, Mr. Vani, a response has been given, it didn't.
Yeah, I thought I have provided the response, so I am not sure what the question is, what Council is asking this time around.
Yes, I'll move on because I think we have dealt with it in some detail already. I just wanted to correct.
Mr. Vani,
Yes,
before you move on, can I ask a question arising from your answer earlier? You said the impact of these decisions, the special dispensations, were well known and they happened early on. And when you read this memo, it appears that the NPA did not have cooperation from SABC. I think I heard you say that these were political matters that had to be resolved. Did I hear you correctly?
Maybe partly you heard me correctly insofar as it's It's political principals who are responsible for different departments. So maybe if I explain it that way. So SABS have a political principal, DOJ has a political principal. So if there were issues that they didn't see eye to eye on any matter, there is a forum where they can talk at a political level to resolve issues. So I'm not going to speak for them, but there are these fora that exist. And one of those fora that I can remember clearly would have been the JCPS cluster. In this particular case, however, to my recollection, at least when I was there as the chair of the JCPS cluster, the matters of the NPA were never surfaced to the level of the JCPS cluster, and there's a reason for that. Because the JCPS cluster dealt with matters that are of an urgent nature, now, here and now, and trying to address those matters. And so matters that are of historical nature and have their own, what is the right word? I lack the right word, but they have their own manner of resolution. Those matters would then be resolved through that manner of resolution, and the TRC cases had its own manner of resolution and would have followed that manner of resolution as opposed to the short-term nature of the JCPS cluster mandate.
Okay, so just on that, we've heard evidence from another DG who said the role of the DG, well, DGs are accountable to their political principles. Would you agree with that?
Primarily, I would agree in the sense, this is a person who is your immediate boss, and therefore you are accountable to him or her, because they are your immediate boss. And if only things don't work out between the two of you, can you then elevate the matter either to the Public Service Commission or the presidency? So yes.
Okay, and during your time, the TRC cases, you say, did not arise at the JCPS cluster when you were chairman?
I cannot recall them ever being elevated to that level. Again, I can only imagine and assume that that was a reason because they had a way of being resolved compared to the high levels of crime, rapes, and all those types of cases where specific interventions are needed. Those interventions are generally of a short-term nature to quell the environment and then give the relevant people who must deal with those matters time to plan and do the other things. And that's when matters then get elevated to the JCPS cluster to give them the immediate attention, address, put to rest, and then go to your long-term policy and strategy on how to deal with those matters going forward, including the drafting of legislation and related interventions.
And you say the TRC cases had their own way of being resolved. Explain that.
The TRC cases, after the TRC process, there was a process where these cases were elevated and were given to SABS for investigation, which would then have channeled them to the NDPP for prosecution. So there was a very clear process, and they resided under a particular, so to speak, unit within the NPA to be dealt with. Well, there are many processes, it's a long thing, but that's what happened. So the TRC cases would have fallen under a process where the formality of that process was understood. The entities that needed to deal with those cases were understood between the NPA and SABS, and the outcomes obviously would depend on a case by case basis, noting the amnesties that were given in between these cases. So that's why I'm saying they were a particular special breed, as it were, of cases that had their own roots in terms of how they were advanced.
Okay, thank you. Thank you, Mr. Varney.
Thank you, Commissioner. Ms. Ndoni, I just want to pick up on one of your answers to Commissioner Gabriel. You were speaking about the JPS cluster, and that it only dealt with urgent matters. Incidentally, there is evidence before this commission that the cluster in earlier years did deal with the TRC cases. In fact, they even had a special subcommittee on the TRC cases. But in relation to your answer, you said because they weren't urgent, they were historical in nature, that they had their own manner to be dealt with, and you've explained that. Do you not agree that the TRC cases were in fact quite urgent, simply because they were so old, the cases were serious in nature, had not been attended to previously, and suspects and witnesses were dying off at a regular rate, to the point where, today, virtually all of them have died, and those cases can't be resuscitated. So I want to put it to you that even during your time, the TRC cases were urgent.
If I said they were not urgent, that's not what I meant. I wasn't saying they were not urgent. I said they had their own mechanism to be dealt with. That does not take away the agency. It's that mechanism that I was just putting before the commission, that there was a mechanism through which they would have been dealt with, compared to the other short-term cases that needed to be dealt with differently. If I use the World Cup as an example, because that's a practical example, the World Cup cases where we had to move mountains to create special courts for those cases so that they could be dealt with, completed as the World Cup completes or soon thereafter, and then that's it. You close the door on those, you move on to your normal business. That is the context within which I was talking about the JCPS cluster dealing with cases almost on a project basis, rather than on we're dealing with a matter that is coming from that long ago. It is here now, not in a manner that is insensitive to people, because for the victims and the victims' families, those cases, I would agree, they would want them to be resolved as soon as yesterday.
Thank you. Let's turn to page 30. That's the last page of the document we're on. And I want to draw your attention to the middle of the page where Mr. A.C. Nel, MP, Deputy Minister of Justice, he signs the memo on the 6th of July 2013. And then he writes, can a cabinet memo be drafted for submission to cabinet? Do you know if such a cabinet memo was drafted and submitted to cabinet, and if so, what transpired?
I wouldn't know, as I sit here, whether the cabinet memo was drafted. I would imagine it was, but I didn't find it or lay my hands on it or asked for it necessarily.
Thank you. And I might be wrong, I stand to correction, but as far as I'm aware, we don't have a copy either. Madam Chair, we would ask the evidence leaders and the team to see if they can trace that cabinet memo. And perhaps I think we also need to hear from Mr. Andre Nel, the then Deputy Minister of Justice and the current Deputy Minister. Let's turn to the next document, and that's at page 31. And this document is also a ministerial memorandum, and also from Advocate Jiba, acting NDPP, addressed to Minister of Justice Radebe, and it's titled
Khampepe, not Sunguni, Khampepe, yes.
Radebe. Thank you, Commissioner. It's titled Kidnapping, Torture, Disappearance and Murder of Nokuthula Simelane. It's dated 13 August 2013. And let's just read the purpose of the memorandum at paragraph 1. The purpose of this memorandum is to inform the Honourable Minister of Developments in connection with the above matter as a result of threatened legal action against me. The Honourable Minister was copied in 2 letters addressed to me by the Legal Resources Centre. So would you agree that this is an example where, or perhaps before we do that, if we can just go to page 34. That's the last page, and you'll notice in the middle of the page that you have noted this and signed it on the, looks like the 6th of August 2013. I'm not sure if that date is correct, but do you confirm that?
No, I will not confirm that I signed the memorandum, but it was signed on my behalf, but I didn't sign it.
Yes, I see it's PP. So somebody signed on your behalf.
Yes.
When something is signed on your behalf, I assume they have authority to do so, and the matters in question are brought to your attention.
No, I was just clarifying that that's not me who signed, but it was someone who was duly authorized to sign. Thank you.
Yes, and typically when somebody is authorized to sign, they would bring the matter in question to your attention.
Indeed, it happens, but sometimes it doesn't happen immediately, but yes, it happens that matters are brought to your attention as the incumbent.
Right. And so here we have an example of details of a specific case being brought to the attention of the Minister and the DG. You accept that?
Sorry, I did not understand the question.
Do you accept that this letter is an example of the details of a specific case being brought to the attention of the Minister and the DG by the NPA?
Yes.
So then let's turn to page 33. And there, Advocate Jiba makes reference to her earlier memo at paragraph 2.4, explaining why such cases were not investigated from 1998 to 2009. I think that should read 2010. And then she makes reference to the fact that the NPA has been placed on terms by the family of Nokuthula Simelane. That was Tembi Nkadimeng at that time. She's now known as Tembi Simelane. Do you recall?
I'm trying to understand. Do I recall what exactly?
Do you recall that the NPA and the Minister were placed on terms by Tembi Simelane in relation to the long delay in taking a decision on the case of her sister, Nokuthula Simelane?
Yes, I do.
So under 3, we're not going to go through it, but Advocate Jiba explains while they're still busy trying to make a decision. If you turn to the next page, she says at 3.6, she says, obviously, if the LRC Legal Resources Centre proceeds with the application, it will be opposed. Do you recall, and we've in fact attached, I think, the notice of motion to the bundle, that Tembi Sibilani did bring such a case in 2015, and it actually wasn't opposed by the NPA. It was settled.
I'm aware of that.
And then if we can just drop to the middle of the same page, there is a handwritten note. And I'm assuming that that's not from whoever you authorized to sign on your behalf, but rather it appears be above the signature of Deputy Minister Mr. J. Jeffrey. And it's a very small handwriting. I'm going to see if I can read it into the record. I'm informed by Robin Palmer, advocate for the family, that he was not satisfied with the progress. This matter, I have to say, I can't make out those words. To family members are passing away. Are you able to read that last line? Does it make sense to you?
I struggled the same way as you did.
Okay. I think it says this matter has taken something to family members on passing away. I suspect they're referring to people dying, perhaps. All right, let's then move to page 36, which is the next document in question. And this is a ministerial memo. It's dated the 12th of May, 2014. And it's the subject matter is letter to NDPP to request status report on prosecutions relating to matters emanating from the TRC process, an update on work of the missing persons task team. If we just move to the next page, 37, do you confirm that your signature appears at the bottom of the page, which was signed on the 19th of May, 2014?
Yes, I confirm.
And if we just go back to the first page on 36, and perhaps we can drop to the background as to why the minister was seeking a status report. And under paragraph 2.1, it reads as follows. The TRC unit has been requested by the Director General to prepare a letter to the NDPP on behalf of the Minister, requesting the reasons for the lack of progress on TRC-related prosecutions. Can I confirm that the Director General mentioned in 2.1 was you?
Yes.
Can you explain to the Commission why you made this request?
The concern had been raised with me and had been raised with the minister as well, of the slow pace of the prosecution of these cases. And yes, and of course, at that stage, the minister had not received a report on the update of what the challenges were and related matters, which used to happen previously. And that was the reason why this matter was elevated, and a need for a report was deemed necessary.
So you accept that the reason why you initiated this action was because of systemic issues plaguing the TRC cases?
Maybe I wouldn't put it that way. Let me put it the way I understand what the intervention sought to do. If we start with the TRC cases, indeed they had taken long, but the emphasis here was that the minister was receiving reports telling him of the challenges, telling him of progress, however small that progress would have been, and the like. And then suddenly there was this inordinate amount of time where no report had come to the minister. And obviously we live in South Africa, and we talk to people. Part of the things that are not here is the engagements that I used to do with the communities, with people related to the TRC matters which we reported on. And so these matters would come in that way, and you will not be expected to pretend that you haven't heard about them, and therefore you do something, which is why I initiated that process.
Thank you. That's good to know. So the concerns were being expressed at different quarters, and it wasn't a specific person that raised it with you. You're saying it came from multiple sources.
Yes, no, I didn't sit with anyone in specific terms who said A or B, but these were matters that would arise. Again, I've made reference to the consultations I used to do with communities, partly in person, and I did quite a bit of those consultations with the civic society in relation to progress on each of the elements of the TRC that arose from the TRC, which needed to be actioned. And it is within that context that matters of this nature would arise, and I would then take action as required. But as you can see, the action I took wasn't to go to the NDPP directly and say, why are you not prosecuting? I went to the NDPP's boss and I said, please, can we receive a report so that we can act and be put in a situation where we can respond to the families of the TRC victims. Thank you.
Thanks for that. So we were aware that around that time, in terms of the enrolling of, say, inquests dealing with these TRC cases or enrolling prosecutions, that none were enrolled following the plea and sentence agreement in 2007 on the Chikani case, all the way through to early 2016, when indictments were issued in the Nokuthula Simelane case, following the litigation launched by Thembi Simelane. So would you agree that when you took this initiative in May 2014, that matters were now coming to a head, and that the non-delivery was unacceptable.
Of course, if you lose anyone, as these families did, action is expected as speedily as possible. And yes, in that context, yes.
Thank you. I just want to put on the record the handwritten note that was appended to the signature of the previous document. My attorneys have just put it before me. It reads as follows. I'm informed by Robin Palmer, advocate for the family, that he was not satisfied with the progress. This matter has taken some time and family members are passing away. Chairperson, I've also been reminded that we passed the tea adjournment. I expect to take probably another 20 minutes, but I leave it in your hands, Chairperson.
Yes, you will be 20 minutes longer, Mr. Vani.
Approximately.
Yes. I am quite alive to the fact that Ms. Sindani is not well, and I think this would be an appropriate time to take a comfort break of 10 minutes.
Mr. Chair, please.
So we'll adjourn until 11:25. Mr. Vani, are you okay, Ms. Sindani?
Yes, thank you, Chair.
Yes, Mr. Vani?
Thank you, Chairperson. Ms. Sandani, we're not going to be that much longer. So if we can just stay with the document we were dealing with before tea time, that's at page 36 of the bundle. So can I ask, did the NPA provide the status report that had been requested?
Sitting where I'm sitting, I cannot recall as a matter of fact, and I've only relied on the documents that are before me, so I cannot recall that. Thank you.
We've also done our best to try and recover as many documents as possible from the Department of Justice and the NPA. So the next document, which is in the form of a report on the TRC cases, is the one that's at page 40 of the bundle. And it's a memo in terms of Section 33(2)A of the NPA Act. It is titled Report on Investigations and Prosecutions Emanating from the TRC. It is dated the 15th of July 2015. And it says under paragraph 1, the purpose of this memorandum is to provide the Honourable Minister with a comprehensive report on the investigation and prosecutions of matters emanating from the TRC. But this memo was only delivered 1 year and 2 months later. So can I ask, did you and your office follow up, given the alarm raised in your request of May 2014? Did you follow up as to where the report was, or why it was not being delivered?
If I said I did, it will be just talking from memory, and I hate to do that because my memory is not the best. But that said, a whole range of things happened during this time, and I think context is always important because things don't always work on a straight line basis. The memorandum, as you would recall, was written to the then NDPP, trying to remember which one was it at that time. And then there was a change in the NDPP. Oh yes, it was Mr. Ngasan at the time. And then there was a change in the NDPP, and then there were acting NDPPs and related issues. Obviously, those issues do affect continuation of the conversation. In my memory, I really cannot recall when the report was submitted relative to when it was requested. So I request that I do not answer that question. Thank you.
Well, even noting the change in NDPP, you would accept that a lapse or a delay of a year and 2 months is an unacceptable delay in providing a report on an urgent matter.
Agreed.
And in the documents that have been provided to us, from Department of Justice, we see no correspondence following up your May 2014 memo requesting the status report. You accept that?
As I've indicated, I cannot recall from memory what transpired, whether there was a follow-up or not. That I cannot say.
All right, well, then let's turn to the next report on the TRC cases. That's the one at page 40. That's dated 15 July 2015. It's from Advocate Abrams, NDPP, to Minister of Justice Masuta. Let's just quickly jump to the last page of that document, which is page 62 and 63. And this is the conclusion page as well as the signature page. And you'll note that this version of the document is unsigned. Doesn't bear Abrams' signature. Your name is mentioned under his. It's unsigned, as well as that of the Deputy Minister and the Minister on the next page. However, Mr. Abrams has actually appeared before this commission, and he did give evidence on his memorandum. And according to Mr. Abrams, it was submitted to the memo. With the leave of the chair, I'm just going to read in one paragraph from Mr. Abrams' affidavit before this commission. That's his affidavit that is dated the 12th of December 2025. And paragraph 60 reads, following my appointment as NDPP on 18 June 2015, as early as 15 July 2015, I submitted a memorandum to the Minister pursuant to Section 33(2)A of the NPA Act in relation to the investigation and prosecution of matters emanating from the TRC. The memorandum would have preceded an in-person meeting between the Minister and I, during which I would have briefed him on the history and status of the TRC matters. You don't have any reason to dispute what Mr. Abrams says?
No, I don't.
All right. Now this memorandum is a particularly long one. We are not going to traverse it in any detail, and moreover, it actually is quite repetitious because it does repeat facts and figures from the previous memorandum we've already been through. But essentially, it covers similar ground because it explains why these cases haven't gone ahead. Perhaps we can jump to paginated page 48. And there you'll see similar paragraphs dealing with at 310 DSO SAPS declining to investigate those 50 cases. Reference to the guidelines, we're not going to traverse that again. If you turn to the next page, you can see that repetition in relation to SAPS not investigating cases pending the outcome of the Ginwala Commission. The next paragraph dealing with the appeal, turn to page 50, and then you have the need to start negotiating with SAPS to investigate, and then the World Cup itself. So we've dealt with all of that. Let's move on, and perhaps let's go to the end of this document. The heading Matters of Current Concern at page 60. So I just want to read into the record some of these passages for your comment, because these are quite alarming statements that NDPP Abrams makes about the TRC cases. And I'm going to start at the very last paragraph, 6.2. Unfortunately, the quality of investigations is very poor and is having a negative impact on being able to finalize the cases. 6.3, he speaks of the failure for the matters to be investigated from 2003 until 2011 has prevented prosecutions being instituted in cases that could possibly have resulted in convictions. This is because the time the cases were eventually investigated, the suspects and the witnesses were already deceased. And he points to Karak 4 and PEPCO 3 as examples. 6.4, consequences of the failure to investigate will be placed in the public domain once inquests are held in certain matters or when decisions not to prosecute are announced. 6.5, he says a particular case in point is the Nokatula Simalani matter, where a formal inquest before a judge will be held. It is a fact that evidence will be led of key witnesses being dead and key evidence being unable to be located. It is only to be expected that the judge would require an explanation as to why this matter was not investigated prior to 2011. And then he refers to affidavits he attaches, that of Advocate Macaulay and Advocate Ackerman. And on the next page, he says, both advocates allege high-level political interference aimed at preventing the investigation of TRC cases in their affidavits. These affidavits are filed as part of the application to compel a decision, and it is not inconceivable that the victims may call these advocates as witnesses if this issue is in fact raised. And then lastly, 6.6, it is only to be expected that once the decisions are publicly announced and the failure to investigate exposed, that allegations will be made that government deliberately waited for all the witnesses and accused to die before giving attention to the cases. So, firstly, would you agree that these are these statements of fears expressed by Advocate Abrams, that they really are quite alarming?
Yes, I would agree with the advocate in how he sums up the concerns, the fears, and the spirit with which he raises those issues. I agree with him.
So, can I ask, what was the reaction of your department to this memo?
Reaction in what way? Maybe just, I don't want to assume I understand the question.
Well, given these dramatic statements that Advocate Abrams is making, one assumes that there would have been some reaction and a response and perhaps looking at the way forward and how to resolve matters.
But if you say her department, did Mr. Masuta, Mr. Jeffrey say they received this memo? Because if you speak to of department, I think the buck here should possibly stop with Mr. Masuta, departmental.
Yes, I totally agree, Commissioner, that ultimately the buck would stop with Mr. Masuta, the Minister of Justice. Although I would also imagine that the Minister would rely on the views and recommendations of the Deputy Minister and the Director General.
Yes, but what I needed to know is maybe you could remind us whether Mr. Masuta says he saw the memo and what he did.
So, unfortunately, if my memory serves me correctly, this memo only materialized after Minister Masuta had given evidence
Okay, yes, continue.
So, can you recall whether you had a particular response to this memo, and if you made any recommendations to the minister?
I cannot recall my reaction, and if there was a reaction, it would have, in all likelihood, surfaced in the memorandum. So I cannot recall that reaction necessarily.
So, I note that your tenure as Director General ended in March of 2016, and this memo was put up in July 2015. So you only had, what, another 8 or 9 months in office. But in the balance of those 8 or 9 months, do you recall any further steps being taken, either by the minister or yourself, in relation to the TRC cases?
I do, again, maybe it's, if I can contextualize, again, when I respond, I'm not responding to what I did on the TRC cases, because the expectations were not for me to do something that is specific on the TRC cases. That's a conversation between the NDPP and the minister, and if the minister guides and say provide or develop a memorandum that goes to cabinet to discuss these issues, that would have been a natural reaction. I do not recall necessarily this memo specifically at the time, but I also don't say it wasn't routed through my office. I just do not recall it. I do recall the then NDPP advocate Sean Abrams meeting with the minister then, Minister Masuta. I do recall those meetings. I wasn't party to them though, and I wasn't necessarily required to be in those meetings. So I cannot confirm the reaction of the minister necessarily about this memorandum. Thank you.
Right. Although in relation to, you know, any onus that rested with you, I just point out that in May 2014, you took action after you had spoken to families and heard concerns from various sources. So that prompted you to take action in May 2014 and to recommend to the minister that he take action in calling for the status report. So, you know, it certainly was within your purview to take that kind of action. I'm certain you agree with that.
As I've said earlier, commissioners, in responding specifically to this memo, that's the only thing that I was saying, that I don't recall specifically seeing this memo. I'm not saying I didn't see it, but it doesn't jump at me as a memo that I would have seen at that time. And that's the only thing I'm saying. If you are asking me today, does a memo like this worry me? Yes, it did. It does worry me now. But as I said earlier, at that time, I'm not sure I saw the memo. If I did, I'm not sure what reaction it would have provoked. But when I read it today, it's quite a sad state of affairs. Thank you.
Thank you. then lastly, I just want to probe with you an issue that Commissioner Como raised with you during your evidence in chief. And this dealt with the question of the victims and how to assist them. And with the leave of the Commission, I just want to quote what Commissioner Como said. It's at page 32 of the transcript of Ms. Ndani's evidence in chief on 28 July. That's day 65. And Commissioner Como asked you, I quote, okay, just on the question also of reparations, the TRC Commission also recommended reparations. And let me ask you this way first, how do you deal with the issue of reparations? You referred to it. And then later in your evidence, he makes the point that, not reparations, but constitutional damages are part of the terms of reference, which is also why the Kalata Group asked for and the President obliged. We are supposed to look at constitutional compensation. It seems we may hit a brick wall. I would want your comment on this. In your response, you made reference to the reparations that had been provided in the past. And in relation to the question around constitutional compensation, you indicated that you didn't understand what constitutional reparations meant. So, now that you've heard the term constitutional damages, would you be familiar with that form of relief?
Please, can you go over that again?
Yes, sure. So, just to rewind, and I'll explain why Commissioner Como posed it to you in the terms of reference of this commission. One of the matters they must look into is whether constitutional damages should be paid to anybody arising from the fact that the bulk of these cases were not taken ahead, and if so, in what amounts. Now, that in turn arises from a claim for constitutional damages that the 25 families known as the Kalata Group launched in January of last year. They are seeking constitutional damages arising from the same set of facts. And constitutional damages is essentially a form of relief for purposes of vindicating rights that have been egregiously violated over a protracted period of time. So now that you're familiar with the relief, you're aware that this is part of the Commission's terms of reference. The question I want to pose to you is as follows. I think it's common cause amongst the parties that, by and large, these cases were not taken forward. I've already pointed out that in certain years, more than 8 years, not a single inquest or prosecution was enrolled. It was between 2007 and 2016. You have heard the evidence of the NPA that for a period of time, particularly between 2003 and 2010, few, if any, investigations were initiated. So this really has resulted in most of these cases collapsing because witnesses and suspects have died. And as mentioned previously, It's very difficult to resuscitate many of these cases. Most can't be resuscitated, so the damage is done. So the question to you is, do you agree that constitutional damages should be afforded to the families? And if so, perhaps you can explain why.
I think a question of that nature requires a personal feeling, which I want to stay away from and rather just try and deal with the facts that are before the Commission. To the extent that there were delays in the holistic government between SABC, NPA, and the various, I think the right word is amnesty, but I'm not sure whether it's the correct word, and the various amnesties that were given in between on these matters, and the lapse of some of them due to prescription, the 20-year prescription on prosecution of these cases. If you take all of that and you put it together in one basket, it does paint a very unfortunate picture that we wouldn't want the families to have experienced. So if I put it that way, that would be my articulation of how I feel about these matters. And the in everything that happened, again, when I say it's unfortunate, I don't want to minimize the pain that families felt and continue to feel even as we speak here, because that would be unfair on them. But having said that, there were a whole range. If I read the documents, there were, and of course a little bit of my memory, there were a whole range of challenges, I think, between the NPA and SABC, who are really, in essence, the primary actors in dealing or not dealing with these matters, whatever their concerns were, whatever their environment was. But where we are today, I wouldn't say I feel nothing for the families. In fact, I would go so far as to say it's just saddening that we are still dealing with these matters. Thank you.
Thanks for your explanation. In relation to what you say about the issues between SAPS and the NPA, and I assume that you're referring to differences and conflict and the like. Yes, there were certainly those issues from the perspective of the families. We don't believe that can be put up as an excuse for not taking the cases forward. Because the simple fact of the matter is that there were cases that the SAPS took forward from the NPA and PCLU. So the other cases that the PCLU were dealing with, cases dealing with terrorism and nuclear proliferation and the like, those were being investigated by SAPS. There was no issue there. It was only the TRC cases that were not taken forward at that time. And
sorry, can the witness help us really on those issues that you're
Mr.
raising?
Vani, where are you heading to now?
Chairperson, I was taking issue with the reasons she was putting up why the cases were not taken forward. But I accept that I might have been got carried away a little.
Yes.
I'm happy to pause at this point.
Thank you. Ms. Rang. Yes. Thank you, Mr. Vani.
Yes, Chair, no further questions.
Thank you.
Ms. Sindani, I can't remember whether I asked you this when you gave your evidence in chief. You would have sat on the DG's forum. Did the TRC cases come up in that forum during the period 2010 to 2016? I know I'm asking you to cast your mind back, but do you have any recollection of these matters being discussed there?
I'm afraid to say I have a specific recollection of the TRC matters being discussed specifically. Because I don't have that immediate recollection of that. But I would imagine that they could have been discussed. Because even though the DGs would be dealing with mostly short-term interventions, there would be from time to time be matters of a policy nature that drive the conversation into a long-term type conversation. It's unfortunate that trying to cast my mind back, I cannot remember a specific meeting where that was discussed. But I am not ruling it out that it could have been discussed because the DG's forum did not exclude matters specifically by category. It discussed matters either because something would have been a trigger and maybe the issues around families and media and all of that would have triggered that type of discussion. I just, as I sit here, don't recall specifically that. But it's not something that is impossible to find out if the Commission really wanted to know, because there are minutes of these meetings which the Commission, I suspect, would have access to.
Okay, we'll take that up with evidence leaders.
Thank you.
Thank you.
Thank you.
Ms. Rangaka, any re-examination?
Thank you, Chair. No re-examination for this
Thank
witness.
you.
Thank you.
Thank you. Ms. Sindane, we really thank you for having availed yourself, given your health condition, to come and give evidence under cross-examination before this commission. We truly appreciate your presence. You are now excused as a witness.
Thank you. Thank you so much. Can I run now? Can I go?
Yes. 2 of September. 2 of September. Mr. Siminya, am I correct that these proceedings stand adjourned until the 2nd of September at 2 o'clock?
That is correct, Chair.
Yes. These proceedings stand adjourned until Wednesday, 2nd of September at 2 o'clock.